This is 2509380M, the People versus Randall Crane. We ready on Randall Crane? Mr. Crane's coming up. Thank you, Mr. Kazicki.
No.
Mr. Crane, do you have counsel? Was that you, Mr. Barron?
Your Honor, Todd Barrett. I did speak with Mr. Crane prior to the court calling the case today. I think that at this time, Mr. Crane's probably best served proceeding on his own. There are some constitutional arguments that he's raising that I don't think, as a member of the bar, I can.
Oh, is he a sovereign citizen?
He's making some sovereign arguments, yes.
Okay, I have very little patience for them. I will let you know that, sir. So, okay, tell me your name.
My name is Randall Crane. That's a living name. I'm not a corporate fiction.
So you're a real person named Randall Crane.
Person. Okay.
Okay, no, listen to me. Sir, you're here today because you have some charges against you. All right.
I'm challenging the court's jurisdiction.
Okay, well, denied. Your motion's denied. I have jurisdiction to the Constitution of the state of Michigan. What's your next? I'm not arguing with you, sir. I have jurisdiction. So
you have to provide subject matter jurisdiction as well as personal jurisdiction to me before.
I have jurisdiction under the Constitution of the state of Michigan. What else? What else?
You do not have jurisdiction over the national.
I just said I did.
No, you don't.
All right. All right, so sir, do you want to proceed on these cases and talk to the prosecutor? Don't look on your phone while you're talking to me. If you
my notes are on.
No, you listen to me. If you don't know your sovereign citizen arguments well enough to come up here and say them, I can tell you can't have a court. I can tell you can't have. You're here today on misdemeanor charges. No talking. You're brought into court. You've already been arraigned. You have a charge of interfering with police officers in the while they're doing official business. That's a misdemeanor, punishable by up to 90 days in jail and a fine of up to $500. You also have a civil infraction for operating using a mobile electronic device, first offense while operating a motor vehicle. A charge of no proof of insurance. Those are both civil infractions. Civil infraction for no proof of or no registration in a motor vehicle. So those are the charges against you, sir. I'm going to tell you the rights that are actually real rights that you have in this court. You have a right to an attorney appointed at public expense if you are indigent without money to hire an attorney, and if the offense charge requires a minimum jail sentence or the court determines that it might sentence you to jail. The appointing authority will decide if you are indigent and appoint counsel if you are eligible. You may have to repay the expense for an appointed attorney. You may contest your ability to pay the ordered fees if the court attempts to collect any cost for an attorney, and the court must determine your ability to pay at that time. If you have a trial, you have the following rights. You have a right to, this is how trials work. You have a right to call witnesses to speak for you at trial, and you can get an order signed by the court to require witnesses to come to court. You have a right to see, hear, and question all witnesses against you at trial. You have a right to be a witness for yourself or to remain silent. If you chose not to be a witness on your own behalf, the prosecutor could not comment on your refusal to testify. Lastly, you have a right to be presumed innocent unless you are proven guilty beyond a reasonable doubt. If you enter a plea, obviously, you'd be waiving those rights. You also have a right to be released on bond. Now, it looks like you previously stood mute on these charges, so you're here today for a pretrial. You have a few options, sir, under the law of the United States, the Constitution of the state of Michigan, and statutory law and court rules in the state of Michigan. You can either retain your own attorney to proceed on this case, or you can have a pretrial with the prosecutor directly and try and work out an agreement, or we can set it for a jury trial. Okay, those are your options. You can get an attorney, use a court appointed attorney, but you understand that attorneys have an obligation to follow the law and not make frivolous arguments, which is what you want to make today. And if an attorney makes those arguments on your behalf, I could sanction them. So no attorney on this green earth is going to come in and make the frivolous arguments you're making on your behalf. Or you can speak to the prosecutor, or we can just set it for a jury trial. Out of those, I don't want to hear it. I want you to pick out of those 4 options what you want to do. Hire an attorney, speak with court-appointed attorney, talk directly to the prosecutor to work towards a resolution, or set a jury trial. Pick.
Let me ask you a question.
No, I asked you a question, and I'm telling you to answer it.
And I have the right to understand my rights and understanding.
Sir,
exactly
here,
what-
can you hand him this form? These are your constitutional rights I just read to you. Why don't you have a seat? You have a seat, read your rights, and I'll call your
Your
case
Honor,
back
I
up.
am asking for you.
Have a seat right now
What
and
was
read your
oath of
rights.
Office.
Buckle up, guys. Today we're going to watch the tension build before the first words are even spoken in court. The case is called. The judge's tone set the atmosphere, and the viewer can already sense a clash coming. The introduction frames a power dynamic and hints at the stubborn defiance we're about to see. As this brand new sovereign citizen confidently walks into a courtroom, he has no idea is ready to challenge every claim he thinks he understands.
And read your rights, sir. If you
I
don't
read-
understand them, read them.
I move for this court to dismiss.
Have a seat.
Where is he? Okay, well, that might never happen, but, what was that guy's name on that file? Because I'm assuming did he leave?
Cream. He did.
Did he leave?
Yes.
Well, he's big mad. Well, I need that file, because I'm gonna give him a bench warrant. All right. All right. Are you okay, Amy?
Yeah.
I'm coming. I promise I'll get to you real.
RFK Jr. is correct. Fluoride in water has hardened a lot of brains.
I'm just, you know what? I know I should be more patient. I'm so tired of the sovereign citizen. All right, we're coming back up. This is 2509380M, the City of Taylor versus Randall Crane. Mr. Crane, you want to come back up? Mr. Crane, did you have a chance to go over your constitutional rights that I provided to you?
Yes, I understand my constitutional rights.
Okay, thank you, sir. So at this time, I gave you 4 options. Would you like to retain your own attorney? Would you like to speak with House counsel and have an appointed attorney? Would you like to meet directly with the prosecutor? Or would you like to set the matter for jury trial?
I'm going to be requesting for an order of change of venue.
Denied. Anything else? There's no basis for that, sir. So I'm asking you, we'll just set it for a jury trial, okay?
I have to understand everything in regards to my case.
Sir, I gave you your constitutional rights so that you could review them. I also gave you the attorney,
I understand that,
court-appointed attorney to go over those rights with. So I gave you an opportunity to understand your rights. I'm not going to entertain, listen, I'm not entertaining your sovereign citizen arguments because they're unfounded and they're not legal. There's no legal basis for them. So I'm not doing it. So now I'm asking you, out of the 4 choices I gave you, which one would you like to do?
I am required to understand everything in regards to my case,
Okay.
including subject jurisdiction matters.
All right, well, you could do your research. I'm setting this for a jury trial. We'll see you back for your jury trial on November 14th of 2025 at 9:00 a.m. I really recommend you retain an attorney prior to that date, sir, because I know I'm going to tell you what you're not going to do: waste the citizens of Taylor's time with your nonsensical arguments. You're going to come in. You're going to try your case. Again, if you want to talk to House counsel, you could do so. All
I'm
right.
not wasting the city of Taylor's time.
Okay, good. We'll see you on your trial date. Have a good day.
Mr. Walker, let's see. There's somebody signing up for pretrial. Screen name, Samsung. There we got sound on Samsung. What is your name?
I'm Jonathan Wiggins.
Okay. Your ticket is 25RO03001. This is a speeding ticket that was issued on the 9th of May at about 1:30 in the morning. You're eastbound 11 Mile in Lafayette. You were cited 35 and a 30. You can admit or deny responsibility, or you can admit responsibility with an explanation. How do you wish to proceed?
Not guilty.
Raise your right hands, please. Do you swear or affirm that the testimony you're about to give in this matter will be the truth?
I do, Your
Yes.
Honor.
The officer will testify first, please.
Your Honor, on the listed date and time, I was traveling eastbound on 11 Mile approaching Lafayette when I observed a black 2021 GMC Yukon traveling westbound on 11 Mile, eastbound on 11 Mile when I activated my front moving opposite radar and got a reading at a 47 miles per hour in a 35 mile per hour zone. I also observed the vehicle moving at a very high rate of speed, and that's when I activated my radar. The radar was tested before and after my shift, and I am certified to operate radar, Your Honor.
Thank you. Mr. Wiggins? Sir?
You ready for, you want to hear my statement is what you say?
Yes.
Okay. I'm Jonathan Wiggins. I was coming home from work, 1:30. I take that route.
We've lost sound.
No, he froze.
He froze and we lost sound.
Let's see if I can call.
Do we have a phone number?
We do.
Your Honor, I'd like to just to clarify something. I was traveling, I might have missaid something in my testimony, but I was traveling westbound, the vehicle was traveling eastbound on 11.
I don't know what happened, but it just cut off on me.
Yeah, but we got you back.
Okay.
So where it left off was you said you were on your way home from work?
Yeah, I get off at 1:15 and I take 11 Mile every day, and I know to do 35 miles an hour on 11 Mile Road and 45 miles an hour on Woodward. I don't have no reason to be racing up and down the street. I'm 60 years old. It was a car on the side of me when he was in front of us, facing us. And when he pulled me over, he said, "You know, you pulled me over for?" I say, "No, I don't." He was like, "Well, you were speeding." And I was like, "Well, it was two cars. We were side by side on the lane. So how was I speeding?" And he said, "I visually radared you at 47." And I said, "Excuse me?" And at first he didn't have a radar. When I read my ticket, it says that he used the radar. And then he said, "Well, I'm just going to give you a ticket for 1 to 5 over." I still take this route every day. I'm tiptoeing just to get to 75 so that I can get home. It's kids racing up and down Woodward and all type of sports cars. I'm not one of those. And I didn't like him saying that I was speeding. It was.
All right, guys, here's where the calm opens into confrontation. The defendant leans into sovereign rhetoric, insisting on fiction versus living identity, while the judge responds with unwavering control and a firm statement of jurisdiction. Each exchange tightens a moment as legal reality overtakes fantasy, and the judge methodically lays out the charges, the rights, and the boundaries, refusing to let the hearing drift away from the law for even a single second.
The vehicle.
I was doing 35 miles an hour on 11 Mile Road all the way to 75. I don't know how he clocked me at 47. It was two cars. It was me and another car. We were side by side.
Maybe both of them were speeding.
Why does that show that you weren't going 47?
He was in front of us.
The officer was opposite direction.
Yes, he was facing us. Yes, coming from another direction. Then he turned around and got behind us. Got behind me, and I saw him. So I'm still doing 35 miles an hour down the street. Then he pulls me over. He had the time to read the one car plate next to me, and he had a chance to read my plate. He pulled me over and said that I did 1 to 5 over, but I was really doing 47 or something. And I take this route every day. I work at the hospital. I have no need to race. I have a big Yukon truck. I haven't had a ticket in almost 20, 30 years. So to hear this was kind of like, wow. I'm saying I'm not guilty on the speeding charge down 11 Mile Road. I know the law on Woodward and 11 Mile Road. I do. And that's a chance you just speeding down 11 miles, doing 100 miles an hour to get to 75 is crazy. I wouldn't.
And St. Clair Shores was speeding.
1 to 5 over, was it like that?
Yeah. That appears to be the case.
I'm a good driver, Your Honor. And
I'm not saying you're a good driver.
I don't want to be
Civil
punished.
infractions are not crimes. Civil infractions are mistakes. They don't involve an intent to do evil. If somebody's just driving down the street, it's not unusual that they could be speeding because the speed limit's
Very.
set low. And if you're in a speed zone that's 25 or 30, and you're not thinking about your speed, you're just going from point A to point B, most of us could well be going faster than 30. Now, your speed was measured at 47 before the officer turned around to get behind you.
Allegedly.
Measured as you approached the officer.
He said he had it on radar, sir. He should be able to present that. I mean, he told me
That's not the way radar works.
he told me he clocked me visually.
He told you that he measured your speed with the radar because he observed you to be speeding. That's what motivated him to operate the radar, to use the radar device to measure the speed of your vehicle.
He told me he visually clocked me at 40. But
Okay.
it's okay.
That's not the set. You're taking things out of context. If an officer sees a vehicle approaching and thinks that it's going faster than the speed limit, they're trained. They can give a visual approximation that is going to be pretty darn close. Research indicates that the visual observation speed, not with a radar, but made by an officer, is going to be about 2 miles an hour slower than the car is actually going. But the point is, the officer thought you were speeding. He didn't cite you for what he thought you were going. He operated the radar so as to measure the speed, and he found that you're going 47. You've got a decent driving record, to say the least, and in the exercise of his discretion, he elected not to cite you for the full 3-point infraction, but he gave you a 1-point infraction. He knocked it down to a 1-point event. He's certified to operate radar. The radar unit was checked both before and after his shift. It worked at the start. It was still working at the end of his shift. It didn't break and fix itself some point in the middle. So there's no finding here that says that you were intentionally speeding, but I do believe you were going 47, and that means at least 35. So I do think you're responsible for 35 and 30. That is the speed limit there, 30 miles an hour.
Yes.
And the fine for that is $130. The $130 can be paid online or by mail, or you can pay it at the courthouse counter if you prefer.
Can I eliminate the points, Your Honor?
The points don't come from the court. They come from the Secretary of State. I can't change them.
And you say he checked his radar, not you, right?
Of course, I didn't check his radar. I don't know anything about radar.
He didn't have a radar, sir.
Yeah, he did.
He didn't use. He told me he did not use a radar. It was.
Oh, that's not what he said. He said he made a visual observation of the fact that you were speeding.
It was two cars. It was both of us. It was two cars.
That doesn't mean that either one wasn't speeding. If two cars are going the same speed, that means they're both going the same speed.
Yeah, so pull both of us over.
That's not practical.
Yeah, it is. I don't understand. I just know. You know what I really believe?
I don't think I want to hear.
He got a chance to judge, and that's all I can say.
As he's driving in the opposite direction from you, he has no idea as to how many people are in a car or what they look like.
No.
Buckle up, guys, because this is where tension peaks and patience runs thin. The judge demands order, warnings turn sharp, and when the defendant walks out, the courtroom shifts instantly toward consequences. The bench warrant talk looms until he returns, now facing a different tone and fewer choices. The judge locks the path toward trial. showing exactly how quickly defiance turns into reality when the courtroom rules are tested beyond their limit.
25-40686-GC. Who do we have present for this case?
Jeff Hodges. Good afternoon, Your Honor. Matthew Kassar, P83663, here on behalf of the defendant, Megan Sheldon.
All right, thank you very much. And do we have, anybody here for Jeff Hodges?
Yes, I'm here.
All right, I do see you now, Mr. Hodges. Thank you very much. This is a motion for summary disposition filed by the defense. I'm going to give each side an opportunity to tell me why they believe that their side should win. Counsel, go ahead.
Your Honor, just so I can clarify, I think today, I'm happy to go forward. We did Ms. Sheldon filed a motion for summary disposition. It is set for hearing July 14th, just to comply with the court rules, the 21 days. This was the date and time set for a pretrial. Again, happy to go forward with arguing the motion for summary disposition, but per the court rules, we had to set the hearing out 21 days.
I see that now. Thank you for bringing that to my attention. Mr. Hodges, did you understand what he just said?
I don't. All
right.
The procedure.
The procedure is if they file a motion such as he's filed called a motion for summary disposition, that is a motion that says we win by virtue of what the law says, they have to give you 21 days to respond to that, and that would be on July 14th. It's already set for a hearing then, so 2 weeks from now. However, if you want to, you could allow that to be heard today, and we would just cancel the hearing on July the 14th. If not, we'll probably just come back on July the 14th and we'll argue it then. What would you like to do, today or on July 14th?
I prefer to see what can be solved or not solved today.
Okay, so you want to go forward today and not have the hearing on the 14th, is that correct?
Yes.
Okay, all right. So I'm going to give both of you again an opportunity to argue your sides and to put out whatever information you want me to have. So counsel, this is your opportunity. Go ahead.
Thank you, Your Honor. This is, I trust that the court received the briefs and the motion. This is one of several actions filed by Mr. Hodges in the wake of his termination as a contract worker, ultimately for the end client Wade Trim, Inc., which is a professional engineering firm. Mr. Hodges filed several actions that we believe are frivolous. This is one against Mrs. Sheldon, who was a remote supervisor of Mr. Hodges during his 3 or so weeks as a contract worker. Mr. Hodges was terminated for performance purposes, performance concerns. He was an at-will employee. He was actually terminated from it's called Act Talent, which is a staffing agency that Wade Trim uses to staff some of its engineering projects. This was filed initially as a small claims matter. There's a short affidavit with half a paragraph or so of allegations that are vague, conclusory, do not state a cause of action, and do not state any facts that would support any cause of action under Michigan law. So Ms. Sheldon moves under MCR 2.116C8 and 10. Mr. Hodges' claim, if there is a claim, if there is a cause of action, fails as a matter of law for all these reasons. There's an affidavit from Ms. Sheldon in support of the motion for summary disposition. And I will note, Your Honor, that because Mr. Hodges has not responded, ordinarily, in order to defeat a motion for summary disposition, you would need to respond with an affidavit or evidence of his own to rebut the arguments that are stated in our motion for summary disposition. That hasn't been done. Again, I'm not sure that there would be any reason to do that because, again, there's no cause of action. What it suggests is a wrongful discharge, but he was an at-will employee, not even an employee of Wade Trim. He was a contractor, and at-will employees can be terminated at any time for any reason or no reason. We go into our briefs, and I'll just be brief, no pun intended, but be brief. If there was a cause of action for fraud, that hasn't been pled because all the elements have not been established. If there's a cause of action for intentional infliction of emotional distress, that too fails under Michigan law. And if there was a cause of action for wrongful discharge, as I stated again, under Michigan law, that's not viable. For these reasons, we request that the court dismiss this case.
Of the at will law, but my termination is illegal because I'm a protected employee under the federal laws, and I clearly state so. Seems like the other end has problems of the comprehension, so that's problem one. So I filed a small claim lawsuit against Megan Sheridan for her deceptive action to lie to me for a meeting 2 hours away to drive that incurred significant travel expenses on the last day of the snowstorm here in Michigan. And potentially criminal activities has occurred because after I was unwilling to settle initially, someone in Wade Trim made a false accusation on me, accusing me as a terrorist, trying to get me arrested. And the police report is available in Kent County Sheriff Office. And the CFS number is KSP-01231667-2025. But of course, the prosecutor see the content is nonsense, so they declined to press the charge. And through this process of the bogus baseless attack to fabricate me as the terrorist, online stalking has occurred. So as an additional discouragement of further actions like that, because someone in Wade Trim stalked me online, collecting information, and that includes the CEO of the Wade Trim. So I have to file additional lawsuits to the CEO directly himself to discourage future escalation of the harmful activities against me.
Your Honor, may I respond?
Sure.
So I want to respond to each point made. First, Mr. Hodges, one, did not plead that he's a protected class, and two, there's no evidence obviously offered that he would be a protected class. There's nothing that would suggest that he was anything other than an at-will employee. Also not an at-will employee of Wade Trim or Ms. Sheldon, who's the defendant in this case, which was just one of his remote supervisors. Two, he said he incurred travel expenses on the day that he was terminated. If he did, he was reimbursed for everything, and these proofs are in our papers, so that allegation does not hold any water. And three, the quote-unquote accusation of Mr. Hodges as a terrorist is not true. If you look at, I believe it's Exhibit 2, the Ms. Sheldon affidavit. Exhibit A to Ms. Sheldon's affidavit is a compilation that Wade Trim's Human Resources Department collected of Mr. Hodges' public LinkedIn comments that indicate that he is notorious for filing lawsuits and also has several threatening and violent comments against employers and supervisors and the like, which is why Mr. Hodges was reported to local law enforcement as Wade Trim's Human Resources Department was.
All right, guys, this final part moves us into a new case, but the intensity stays focused as testimony, radar certification, and driving history come together in a measured decision. The judge explains the reasoning step by step, balancing discretion with accountability, and closing the ruling with clarity that leaves no doubt about the outcome. If you enjoyed this breakdown, make sure to like the video and subscribe to the channel, and we'll see you in the next video.
And we have also filed a motion for summary disposition in that case and seeking sanctions for filing frivolous cases against Wade Trim and its employees. That lawsuit obviously is not up for today. It's coming for hearing on July 21st, but we will be seeking the same dismissal and also costs and fees in order to have to defend against that case. In addition, Mr. Hodges filed a petition for a personal protective order against Mr. Andrew McCune, who's the president and chief executive officer of Wade Trim. This is also a frivolous filing, also requiring Wade Trim